Be ready. 5 seconds. Start. While considering the first question, the High Court concluded that in as much as an order of ejectment of the plaintiffs from the land in dispute under section 163 of the HP Land Revenue Act 1953 was passed on 2/4/1970 by the settlement officer, the suit having been filed about 19 years after such order is barred by limitation stop. After arriving at such conclusion on question number 1, the High Court, without going into the second question or adverting to the case of the plaintiffs by order dated 4/1/2000, allowed the second appeal, set aside the judgments and decrees passed by the trial court as well as by the lower appellate court, and dismissed the suit of the plaintiffs as being time barred stop. Challenging the said order, the plaintiffs have filed the present appeal stop stanza. We have already extracted the first substantial question of law, which relates to limitation stop. The High Court proceeded the said issue on the ground that though the order of ejectment of the plaintiffs from the land in dispute came to be passed by the settlement officer on 2/4/1970, however, the plaintiffs filed the suit number 41 of 1989 only on 23/2/1989 before the senior sub-judge Mandi, which was barred by limitation stop. The High Court, in arriving at such a conclusion, relied on section 163 of the Act stop. Learned counsel for the respondents herein pointed out that the order said to have been passed on 2/4/1970 by the settlement officer was not communicated to them stop. It is also their claim that they were not issued notice or afforded an opportunity to put forth their case before passing an order by the settlement officer stop. In fact, neither before the courts below nor before the High Court the proceedings dated 2/4/1970 was produced by the defendants stop. In fact, there is no specific plea in the written statement as to the limitation, and no issue was framed by the trial court, and no point was determined by the lower appellate court stop. We verify the defense stated in the written statement, issues framed by the trial court, and the points determined by the lower appellate court stop. There is no such plea and issue as to the limitation stop, though it would be open to the parties to the suit to raise the plea of limitation before the High Court. As pointed out earlier, the defendants have not taken any effort to place the alleged proceedings dated 2/4/1970 of the settlement officer stop. It is not clear how the High Court arrived at a specific conclusion that suit filed by the plaintiffs was barred by limitation stop. Even according to the defendants, the entire records relating to the said proceedings were lost stop. We have already referred to the fact that such issue was not raised and argument before the courts below stop. On the other hand, the plaintiffs concentrated that they are entitled to decree in respect of the suit property based on the continuous and uninterrupted possession for over a period of 40 years stop stanza. In view of the assertion of the plaintiffs that they were neither heard nor afforded an opportunity in the alleged proceedings dated 2/4/1970, the onus is on the defendants department to place those relevant record to show that there was valid by the competent authority stop. Admittedly, such record was not called for, and no material was placed before the courts below, including the High Court record stop. On the other hand, based on the acceptable oral and documentary evidence regarding the claim of adverse possession, the trial court decreed the suit, which was affirmed by the lower court, stop. Inasmuch as the High Court dismissed the suit only on the ground of limitation and not gone into the claim of adverse possession by plaintiffs, in view of our conclusion and disagreement with the High Court's decision, we have no other option except to remand the matter once again to the High Court for disposal of the second appeal afresh in respect of other issue, that is adverse possession stop stanza. From the aforesaid decisions, it is apparent that while exercising the powers in appeal against the order of acquittal, the Court of Appeal would not ordinarily interfere with the order of acquittal unless the approach of the lower suit is vitiated by some manifest illegality, and the conclusion arrived at would not be arrived at by any reasonable person, and therefore the decision is to be characterized as perverse stop. Merely because two views are possible, the Court of Appeal would not take the view which would upset the judgment delivered by the court below, stop. However, the appellate court has a power to review the evidence if it is of the view that the view arrived at by the court below is perverse and the court has committed a manifest error of law and ignored the material evidence on record, stop. Duty is cast upon the appellate court in such circumstances to reappreciate the evidence to arrive at a just decision on the basis of material placed on record to find out whether any of the accused is connected with commission of the crime he is charged with, stop. In the light of the aforesaid principles laid down, we shall consider the evidence placed on record to find out whether the courts below have committed any error in dealing with the evidence which can be said to be patently illegal, stop stanza. There can be no fixed or straight-jacket formula for the duration of time gap in this regard, and it would depend upon the evidence led by the prosecution to remove the possibility of any other person meeting the deceased in the intervening period. That is to say, if the prosecution is able to lead such an evidence that likelihood of any person other than the accused being the author the crime becomes impossible, then the evidence of circumstance of last seen together, although there is a long duration of time, can be considered as one of the circumstances in the chain of circumstances to prove the guilt against such accused persons, stop. Hence, if the prosecution proves that in the light of the facts and circumstances of the case there is no possibility of any other person meeting or approaching the deceased at the place of incident or before the commission of the crime in the intervening period, the proof of last seen together would be relevant evidence, stop. For instance, if it can be demonstrated by showing that the accused persons were in exclusive possession of the place where the incident occurred or where they were last seen together with the deceased, and there was no possibility of any intrusion to that place by any third party, then a relatively wider time gap would not affect the prosecution case, stop. We have noticed the decision, stop. However, the circumstances in the present case are not similar to the case where the event of the last seen together has very close proximity with the time and place of the commission of the crime, stop stanza. In the light of the factors that evidence regarding the recovery of the incriminating materials from the accused persons has been discarded, that there has been sufficient time gap between the instances when the accused persons were last seen together with, stop over.